Okay, let's start with the forecast for common tax. Again, hopefully may lumabas at makatulong naman sa mga mag-exam bukas. So let's go. First question. Chair Staku Robles challenged a Court of Appeals decision arguing that the court wrongly ruled they weren't employees of Lucky Recalde. JR initially worked as a caretaker at Bini Beach Resort, a property run by Lucky's parents. He worked daily from 5 a.m. to 9 p.m., including holidays and weekends, for a weekly allowance of 100 pesos. In 1995, JR took on additional work at the family fish pond, where his pay was tied to the harvest income. This arrangement lasted around 7 months due to the fish pond's poor performance. Despite this, JR continued as the caretaker at the resort. In 2007, Staku began managing a store at the resort, earning up to 1,000 pesos per month, plus 15% commission on rentals from cottages and the rest house. Later, Lucky informed the couple that he would lease out the resort because it wasn't profitable and their services were no longer required. The Robleses then filed a complaint claiming they were illegally dismissed and denied due process. Lucky denied that JR and Staku were his employees, asserting instead that they were industrial partners. He claimed that JR, starting in 1993, partnered with his mother in the fish pond business, earning a third of the harvest and a weekly allowance of 230 pesos. Lucky stated that he continued his partnership when he took over. He also described Staku as an industrial partner, managing the store under a similar arrangement with a monthly allowance and a commission on rentals. Question: is Lucky an industrial partner of JR and Staku? Answer: no. Lucky is not an industrial partner of JR and Staku because there is no evidence to establish the existence of partnership. Lucky relied solely on his own statements that JR and Staku did not receive wages, but merely allowances and commissions from the profits of the partnership. However, it is beyond dispute that receipt by a person of share in the profits of a business does not by itself establish the existence of a partnership. If the amounts are received as wages of an employee, neither does the sharing of gross returns establish partnership, most especially in the light of the absence of any other evidence to establish the existence of the partnership. Note that the existence of a partnership is established when it's shown that first, two or more persons bind themselves to contribute money, property, or industry to a common fund, and second, that they intend to divide the profits among themselves. In this case, there is no clear indication that the parties agreed to contribute money, property, or industry to engage in a particular business, based on the case of Spouses Dusol versus Lazo, a 2021 case. In March of 2009, a group of insurers, including Bini Insurance, issued policy number HOF to I Feel Good Electronics. The policy insured all the company's properties against physical loss or damage, including fire, for the period from March 31, 2009 to March 31, 2010. The policy included a clause stating that if a claim is made and rejected and no action or suit is filed within 12 months of the rejection or arbitration award, the claim is considered abandoned and cannot be recovered. On May 2009, a fire damaged I Feel Good Electronics building, including its production equipment and machinery. The company filed a claim the next day, which Bini Insurance rejected on February 2010, citing an excluded peril. I Feel Good Electronics requested reconsideration, but Bini Insurance denied it again on April 2010, with the company receiving the notice on April 15, 2010. On April 11, 2011, nearly a year later, I Feel Good Electronics filed a complaint for specific performance and damages against Bini Insurance, seeking $1,117,000 in actual damages. Bini Insurance argues that the petitioner's cause of action has prescribed, as the complaint is filed beyond the 12-month period in which began on February 24, 2010. When the claim was first rejected, I Feel Good Electronics, however, contends that the period should start from April 15, when it received a final rejection of its request for reconsideration, ruled on the claim of Bini Insurance that the claim had already prescribed. The claim of Bini Insurance had already prescribed. The claim of Bini Insurance that the claim had already been prescribed should be given due course, because insurance policy is explicit that if a claim is made and rejected, an action or suit should be commenced within a period of 12 months. The accrual of the cause of action for filing of an insurance claim shall commence when there is a final rejection by the insurance company to avoid a necessary suit, which refers to the rejection by the insurance company. The rejection referred should be construed as the rejection in the first instance. For if what is being referred to is a reiterated rejection conveyed in a resolution of a petition for reconsideration, such should have been expressly stipulated. Again, the rejection referred to and should be construed as rejection is that of the first instance. Otherwise, it should have been conveyed in a resolution of a petition for reconsideration, and it should have been expressly stipulated, based in the case of Integrated Microelectronics versus Standard Insurance. Next question. Queen has invested $2.2 million in Bini Builders Queensville project. A year later, both parties rescinded the investment agreement and Builders returned $320,000 to Queen. They agreed that the remaining $1.5 million would accrue interest of 1.5% or $22,500 per month. However, Bini Builders stopped paying the monthly interest and refused to return the principal amount, leading Queen to file a complaint for a sum of money against the Bini Builders and its CEO Tintin Robles. The regional trial court held Bini Builders and Tintin solidarily liable to pay Queen. While appealing the decision to the CA, Bini Builders also filed a petition for corporate rehabilitation before the Special Commercial Court. The Rehabilitation Court then issued a commencement order consolidating all legal proceedings by and against Bini Builders and suspending all actions to enforce claims against them. Bini Builders and Tintin sought to consolidate the appeal case with the rehabilitation proceeding, but the Court of Appeals denied their motion, stating that the appeal would not impact the rehabilitation case since the two proceedings involve different parties, issues, and reliefs. Is the CA correct? Answer. No, the Court of Appeals is not correct in stating that the appeal would not impact the rehabilitation since the two proceedings involve different parties, issues, and relief, because it runs contrary to the provisions of the FRIA law. The FRIA law authorizes the Rehabilitation Court to issue a commencement order that includes a stay order, which have the effects of suspending all actions for the enforcement of claims against the debtor and consolidating the resolution of all legal proceedings by and against it, based on the case of Kaisen Builders versus CA. Next question. HMTU Capital took out a 3 million peso loan from Dilao Bank with a 17% annual interest rate. To secure the loan, HMTU Capital executed a real estate mortgage deed covering its 2 condominiums. When HMTU Capital failed to repay the loan, including interest and penalties, Sining Bank, following the merger with Dilao Bank, initiated an extrajudicial foreclosure of the mortgaged properties. Sining Bank emerged as the highest bidder in the public auction and received a certificate of sale. Consequently, the properties were titled in Sining Bank's name. HMTU Capital then sued Sining Bank in the RTC to annul the titles issued to Sining Bank. The RTC declared the consolidation void and ordered the Register of Deeds of Pasig to restore the titles to HMTU Capital, allowing HMTU Capital to exercise its right of redemption. The RTC set the redemption price at 2.5 million, applied a 6% annual interest rate, and excluded the real estate taxes Sining Bank paid. However, the CA ruled that the redemption price should include the 17% interest rate stipulated in the loan, in line with the former Section 78 of the General Banking Act. HMTU Capital argues that the interest rate for redemption should be 6%, not the agreed upon 17% per annum. Question: is HMTU Capital correct in stating that the interest rate for redemption should be 6%? The answer is no. HTMU Capital is not correct in stating that the interest rate for redemption is 6% because the mortgagee is a banking institution. Section 78 of RA number 337, as further amended by Presidential Decree number 1828, the effective law at the time of the contract of loan and the deed of real estate mortgage were executed in 1997, shall govern in computing the redemption price for the foreclosed properties. On May 5, 2003, Cherry Inc. lodged a complaint with the Bureau of Legal Affairs, BLA, of the Intellectual Property Office, accusing Tingin sa Burger Corp. Of patent infringement and seeking a preliminary injunction with a request for a TRO. Cherry Inc. claimed to be a patentee of the Philippine Patent Number I31138 titled Method of Curing Fish and Meat by Extra Low Temperature Smoking. The patent outlines a process for curing tuna meat by exposing it to filtered smoke, cooled between 0 degrees and 5 degrees Celsius, while retaining the ingredients that exert highly preservative and sterilizing effects. Cherry Inc. had been using this process through Ling Ling Corporation in General Santos City since 1994, which was later succeeded by Pescarich Manufacturing Corp. Cherry Inc. alleged that Tingin sa Burger hired the former Pescarich employee, Bong Alvarado, to build 2 smoke machines and subsequently use the patented process to cure the tuna product. Tingin sa Burger Corp. Denied the infringement claims, arguing that the process did not require a cooling unit, as the filtered smoke was only cooled by ambient temperature before being injected into the tuna meat. Question: was there literal infringement? Answer: no, there is no literal infringement present because there are discrepancies in the elements of the invention as expressed in the claim of Cherry Inc. Jurisprudence states that if the allegedly infringing product or processes falls within the literal meaning of the claims, there is patent infringement. Here, there is none. Was there infringement under the doctrine of equivalence? Yes, there was infringement because the allegedly infringing product or processes process appropriates the innovative concept of the patent, and despite the modifications introduced in the infringing product or processes, it still performs substantially the same functions in the same way to produce the same result. Jurisprudence states that the infringement under the doctrine of equivalence also takes place when a device appropriates a prior invention by incorporating its innovative concept and, although with some modification and change, performs substantially the same function in substantially the same way to achieve substantially the same result. Next question. On September 1, 1989, Attorney Laurenti secured a life insurance policy from HMTU Corp. He passed away on August 1990. Upon his death, HMTU Corp declined to pay the beneficiary, citing Laurenti's misrepresentation of material facts in his application. The beneficiaries argued that HMTU Corp could only challenge the policy's validity within 2 years from issuance and only while Laurenti was still alive. Are the beneficiaries correct? Yes, the beneficiaries are correct because of the incontestability clause. The incontestability clause applies only if the policy have been in effect for at least 2 years. The 2-year period is counted from the time the insurance becomes effective until the death of the insured and not thereafter. Next question. Maloy purchased a non-medical life insurance policy from Feelgood Insurance, naming her wife Colette as the beneficiary. When he applied for the policy, he answered no to a question about past hospitalization but failed to mention her previous stay at Kidney Hospital. After Maloy died in the plane crash, Colette filed a claim with Feelgood Insurance. Upon discovering Maloy's hospitalization, Feelgood Insurance rejected the claim, citing concealment and misrepresentation. Colette sued Feelgood, arguing that Maloy had acted in good faith. Will Colette's suit prosper? No, Colette's suit will not prosper because good faith is not a defense for the concealment on the part of Maloy. The matters which Maloy failed to disclose were material and relevant to the approval and issuance of the insurance policy. They would have affected Feelgood's actions on his application, either by approving it with a corresponding adjustment for a higher premium or rejecting the same. Moreover, a disclosure may have warranted a medical examination of Maloy by Feelgood in order for it to reasonably assess the risk involved in accepting the application. Next question. Josie Trucking entered into a hauling contract with Feelgood's Corp to transport 2,000 sacks of soya bean meal from Manila Port area to Calamba, Laguna. To fulfill its obligation, Josie subcontracted the delivery of 400 sacks to Aya Ancheta. Along with the driver, 3 of Ancheta's employees accompanied the truck. During the journey to Laguna, 2 strangers hijacked the truck. One hijacker carried a bladed weapon, while other was unarmed. Police investigation confirmed the hijacking. Feelgood's Corp sued Josie Trucking for failing to deliver the 400 sacks. Josie responded by filing a third-party complaint against Ancheta, claiming that the loss resulted from Ancheta's failure to manage the cargo. Ancheta defended herself by arguing that the hijacking constituted force majeure. Question: did the hijacking constitute force majeure to exculpate Ancheta from paying any liability? The answer is no. The hijacking cannot be considered as a force majeure because it's not included in the list provided under Article 1734 of the Civil Code, which limits the liability of the common carrier. Hijacking, not being included in the provisions of 1734, must be dealt with under the provisions of 1735, and thus the common carrier is presumed to have been at fault or negligent. To exculpate the carrier from liability arising from the hijacking, he must prove that the robbers or hijackers acted with grave or irresistible threat, violence, or force. Here, there is no presentation or evidence presented that the hijackers acted with grave or irresistible threat, violence, or force. Take note of 1734 and 1735. Next question. Bank teller Mikaya submitted a suspicious transaction report on Hambebe, a politically exposed person. When asked about her 2 million peso cash deposit, Hambebe winked and replied, "Secretote." The Money Laundering Council, the Anti-Money Laundering Council, reviewed the report and found no probable cause to support any belief that Hambebe was involved in any unlawful activity or money laundering. Now, Hambebe plans to sue the bank and Mikaya, alleging discrimination. Is Mikaya and the bank liable? The answer is Mikaya and the bank are not liable because of the safe harbor provision of the anti-money laundering law. Under the law, no administrative, criminal, or civil proceeding shall lie against any person for having made a covert transaction or suspicious transaction report in the regular performance of his duties and in good faith, whether or not such reporting results in any criminal prosecution under the AMLA or any other Philippine law. Here, the bank and Mikaya are only performing their duty under the AMLA to report to the AMLC what is a suspicious transaction. Next question. The Sandigan Bayan charged several public officials with violating the Anti-Graft and Corrupt Practices Act for their involvement in awarding a multi-billion peso contract to Corporation Z. The charges state that the accused received kickbacks from Corporation Z in exchange for bypassing certain bidding requirements. These kickbacks were deposited into their respective bank accounts in the Philippines at the request of the Office of the Ombudsman. The Anti-Money Laundering Council's Compliance and Investigation staff conducted an intelligence database search. The search confirmed that the accused received remittances in their bank accounts across 6 different banks. Question: may the AMLC examine bank accounts of the accused public officials even without seeking a prior court order? Why? The answer is no. The AMLC cannot examine the bank accounts of accused public officials without first obtaining a court order. Under the anti-money laundering law, the AMLC must secure a bank inquiry order from the Court of Appeals to investigate funds and deposits where there is probable cause to believe they are connected to unlawful activity under the AMLA. Okay, let's go to taxation. Binicore Group, licensed by the Securities and Exchange Commission as a regional operating headquarters in the Philippines, provided services to its affiliates both locally and internationally in 2006. The company charged a 0% VAT rate for services to foreign affiliates and 12% rate for services to Philippine affiliates. On its purchases, Binicore incurred input VAT, which it proportionally allocated. However, it did not credit the input taxes related to zero-rated sales against its output taxes due to substantial carryover input VAT from the previous quarters. In 2008, Binicore filed for a refund or a tax credit certificate for the unutilized input tax linked to sales to foreign affiliates. The CTA and bank determined that only a portion of the claim met the criteria for VAT zero rating under Section 108(b)(2). The CTA disallowed the remaining input VAT due to missing VAT invoices or official receipts and failure to meet the invoicing requirement. Is the CTA and bank correct? No, the CTA and bank is not correct because Bunicor only needs to prove non-application or non-charging of the input VAT subject of the claim. Section 112A of the tax code merely requires that the input tax claim for refund or the issuance of tax credit certificate has not been applied against the output tax. There is nothing in the law that rules that mandate the taxpayer to deduct the input tax attributable to zero-rated sales from the output tax from regular 12% VATable sales. First and only the excess may be refunded or issued a tax credit certificate. Note of the instances where the input tax is attributable to zero-rated sales. Next question. In 2008, COMELEC contracted Randomantic and UBEBE to lease electronic voting machines for an election in ARMM. Believing that Republic Act No. 8436 accepted election materials and equipment from taxes and import duties, COMELEC did not withhold EWT or withholding tax on payments to these companies. However, in 2010, the BIR issued a letter of authority to examine COMELEC's books and records for all withholding taxes for 2008. Subsequently, the BIR assessed COMELEC for deficiency of its withholding tax. COMELEC protested the assessment, but the regional director and commissioner of Internal Revenue denied their appeal, prompting COMELEC to take the case to the CTA. The CTA ruled that the COMELEC's responsibility as a withholding agent is separate from its tax exemption on election materials. Thus, COMELEC must pay the deficiency withholding tax. However, the CTA ruled that the COMELEC is not liable for deficiency interest, as Section 247 of the NIRC imposes interest liability on the employee responsible for withholding and remitting the tax. Question: is the COMELEC exempt from the obligation to withhold taxes? The answer is no. COMELEC is not exempted from the obligation to withhold taxes because such obligation is intended to facilitate the collection of income tax. If the income recipient isn't exempt from income tax, the payer must typically deduct and withhold withholding tax on income payments. The withholding agent bears direct and independent responsibility for the correct amount of any tax to be withheld. This responsibility is separate from the taxpayer's liability. The withholding agent is liable only if they fail to withhold and remit the tax to the government based on the 2021 case of CIR versus COMELEC. Next question. In 1971, RA number 6234 established MWSS. Following the national water crisis of 1995, MWSS signed a concessionaire agreement with Maynilad Water Services, Inc. to serve the west zone of the metropolitan area, including Pasay City. However, in 2008, Pasay City Treasurer demanded the payment of real property taxes from MWSS. MWSS contested the demand, arguing that, as a public utility and government instrumentality, they should be exempt from real property taxes. After receiving no action from the city treasurer, MWSS appealed to the Local Board of Assessment Appeals. The Local Board of Assessment Appeals ruled that MWSS, being a government-owned and controlled corporation, was liable for the real property tax. Question: is the Local Board of Assessment Appeals correct? Local Board of Assessment Appeals correct? The answer is no. The Local Board of Assessment Appeals is not correct because MWSS is a government instrumentality with corporate powers which is not liable to local government for real property taxes. Under Section 234 of the Local Government Code, the tax exemption under 234 ends when someone alleges and proves the beneficial use of the real properties has been granted, whether for consideration or otherwise, to a taxable person. Beneficial use means actual use or possession of the property. Actual use refers to the primary or predominant purpose for which the property is utilized by the person in possession. However, a government instrumentality does not lose its tax-exempt status when it grants the beneficial use of its real property to a taxable person. Only the exemption of the real property ceases in this case. Based on the case of MWSS versus Central Board of Assessment Appeals. Okay, that's the end. Thank you.